Hi, everybody. Thank you. And good morning, good afternoon, good evening, wherever you may be. Thank you for joining us today for this installment on Resolutions webinar. My name is Oluwapelumi Amanda Adeola. I'm a partner and solicitor advocate at BHP Law, which is a regional law firm based in the Northeast. I'm joined today by my colleague, Vanessa Sampaio from Flip, which is a firm based in London. She's an associate with them and also sits with me on the EDI Committee of Resolution. We are delighted to be joined today by Andrew Powell, a barrister at 4PB. He specializes in surrogacy law and is here to enlighten us and tell us everything that we need to know, best practice, hints, tips, and how to better present our cases moving forward. Thank you so much, Andrew, for joining us today. I know it's been really, really difficult to try and tie you down with your busy schedule, but we are grateful that you have been able to find some time to provide some much needed education to our members.
Delighted to be here. Thank you for having me. I'm glad we finally managed to get a date in the diary.
Thank you. We're just going to dive straight in because this is a bit more, it's very much like a lunch and learn where people can just log in and just provide some information to themselves as they're having their lunch break. So we're going to dive in with Vanessa posing the first question to you, if we may.
So welcome, Andrew, and reiterate our thanks to you for joining us. So I suppose just starting with the basics, what is it that everyone needs to know about how surrogacy law operates? How does it all work?
I guess I have to bear in mind that we're only meant to be talking probably for around about half an hour, 40 minutes. I'll try and be brief. I think it's a really important thing to start off on, that sometimes there's a perception that surrogacy law is quite esoteric, and if you don't specialize in it, you don't really need to know about it. But actually, if you're a family lawyer, then it's quite important that you do know about it, because it could come across your desk or in a case when you least expect it. And the reason why I say that is because there was a case a few years ago in 2014 that came before Eleanor Kingjay, as she then was, where there had been a case where the child was born through surrogacy but wasn't made the subject of a parental order, which I'll come on to discuss. And so it basically meant that the parents, the intended parents, were not legally recognised as the child's parents. And because they hadn't applied within 6 months, they were unable at the time to apply for a parental order. And the kind of common situation that can happen is because after that case, there was another case before Sir James Mumby, the then president, in 2015, 2014, where he decided a case where a parental order had not been made within 6 months, which is what the statute says you have to do. But in that case, he's basically said you can read the statute down so that it's compliant under Section 3 of the Human Rights Act, and when you read it in conjunction with Article 8 of the ECHR, that it would be basically be unfair not to allow an application for a parental order to come after 6 months. And what followed from that case is that there's been private law cases, for example, where you have your pretty standard, child arrangements order application, and it's emerged halfway through the proceedings that the child was born through surrogacy and nobody applied for a parental order, so that none of the parents, none of the applicant and respondent to the pretty standard Section 8 order is legally recognised as a parent, and worse still, doesn't have parental responsibility. So that's why it's really important to have the basics of it. And so the key thing to remember in relation to surrogacy, as it stands currently in this country, is that the woman who gives birth to the child is always the legal parent. And that means that even if you have a surrogacy arrangement that took place in another jurisdiction, so Ukraine or in America or whichever country where the intended parents are legally recognized as the parents at birth, and America is the easiest example, specifically California, that particular state. In California, for example, the intended parents are recognized as parents in utero, so you can obtain in California what's called a pre-birth order, and that order will say that upon the child being born, the intended parents are recognised as the child's legal parents, and thereafter they're issued with a birth certificate that says they're both the parents, and there's no reference to the surrogate. Now, people often think that that then means that that is then translated or it's recognised in this jurisdiction, but it isn't. So because the woman who gives birth to the child is always the child's mother, under English law, even though you've gone through a process in the US, for example, that recognises the intended parent as parents, it doesn't translate here. And so it gets more complicated if, for example, the surrogate is married, then her husband is a legal parent as well because of the presumption of legitimacy. So you can have a situation, for example, where you might have an opposite sex couple where they've used their sperm and their eggs, so they've created an embryo, and it's been carried by a gestational surrogate in America. She gives birth to the child. She has no genetic relationship to the child. And in England and Wales, the intended parents are not recognised as legal parents. So it can get quite complicated. So it's important that everyone understands it, because if that couple come back to the UK and they don't do anything to regularise the child's status in this jurisdiction by applying for a parental order, then if, for example, they separate and there's a dispute about contact, or they're not married, or they're not married and there's a Schedule 1 issue, then the dad's not a legal parent, or the mother's not a legal parent. So it can get quite complicated. And so basically the parental order is essentially a transformative order, but it's a bespoke order specifically for children born through surrogacy. So in adoption, for example, there's often parallels drawn between an adoption order and a parental order. And they do operate in the same way, in the sense that the adoption order and parental order extinguish the legal status and the parental responsibility, the parenthood of the birth mother and her husband if she's married, and transfer it to the intended parents. But with adoption, you are concerned with a child who has been placed for adoption and parenthood is being replaced by the adopters. Whereas with a parental order, it is an order that is being sought to reflect what was intended. So there's a very subtle difference, because, you know, to qualify for a parental order, I can go through the criteria. Where it's a couple who are applying, it can be a same-sex couple, or it can be an opposite-sex couple. They can be married or in a civil partnership, or they can be in what's called an enduring family relationship. One of them has to be genetically related to the child. So one of their gametes has to have been used. So essentially, if you use donor sperm and a donor egg, which is permitted in some countries, you can't apply for a parental order because you're not genetically related. Would it help if I went through the criteria? Would that be something that, do you think?
Yes, yeah, no, absolutely. And I suppose if you could also let us know what happens in cases where none of the intended parents are biologically related to the child, how they could regularize that status.
So the criteria for a parental order is set out in section 54 of the Human Fertilisation and Embryology Act. And that's basically the key bit that sets out what a parental order is. And working on the basis that it's two applicants, I'll come on to it if it's a single applicant. But the first criteria is that the child has to have been carried by a woman who is not one of the applicants. And it has to have taken place through an embryo being transferred and placed into her uterus, or through some form of artificial insemination. So you can't apply for a parental order where there's been a child's been conceived naturally, where there's been intercourse. The applicants, so where it's two people, have to be a husband and wife, or they have to be civil partners, or two people in an enduring family relationship. The law changed in 2010 to allow more people to apply for it, because pre-2010, only married opposite sex couples could apply for it. Of course, there were no same-sex marriages in 2010 in any event, and pre then. But now it's broadened the eligibility for it. But when the 2008 Act came into force in 2010, it didn't allow for single people to apply for a parental order. But that changed as a result of the case in 2016, where a declaration of incompatibility was applied for by the single applicant who met all of the criteria, and the court basically, well, in fact, the government conceded that it was incompatible with his Article 14 rights on the basis of discrimination. And so what then happened was that the court made a declaration of incompatibility, and a remedial order took place shortly thereafter. Well, not shortly thereafter, it was about 3 years later. So since 2019, single people who have a genetic link to the child can apply for a parental order. So that's about the status of the people applying. You have to apply within 6 months of the child's birth. Now that's what the statute says. And as I said earlier, it was thought up until about 2013, 2014, when a case came before Eleanor Kingjay, that you couldn't apply for a parental order after 6 months. So if the child was born on the 1st of June, you've got to apply by the end of November for a parental order. And once you get into over 6 months, you've missed a deadline. But the case of Rex changed that, and Sir James Mumby basically said, it's prejudicial to the child, really, if you don't make the order. And Parliament couldn't have intended for that to have been the corollary of that arbitrary time limit. And when they kind of looked through Hansard and all the parliamentary debates, there seemed to be no rationale that said, well, it had to be within 6 months. And so, although you can't say to clients, there's no time limit, there is a time limit, and there are consequences if you don't apply, in the sense that you might not be legally recognised as a parent, and therefore you might not be able to consent to medical treatment, for example, or you might face difficulty enrolling a child at a nursery, for example. But if they haven't applied within 6 months, it's no longer seen as being an end to an application. You can probably still apply for it. And in fact, Mrs. Justice Tice, early this year in 2022, she made a parental order in respect of an adult child who was born through a surrogacy arrangement in the late 1990s. And so that adult child was now, I think, in their early 20s, and still made a parental order because they discovered that child hadn't been subject of a parental order. And so you can see the court's willingness to try and make orders where it's possible. So that deals with the time limit. The next provision is that when the order is made, when the application is made and when the order is made, the child's home has to be with the applicants or the applicant in the case of a single person. That sounds quite literal, like the home means, bricks and mortar. But there have been a number of cases where that hasn't been the case, and particularly in the last 2 years or so, where the pandemic has really fractured people's geographical locations, and particularly with international surrogacy, which are predominantly the lion's share of the work that I do in surrogacy cases. It's meant that people have been stuck in jurisdictions and the other parent's been in another jurisdiction, or you've had a child who's been on in a neonatal intensive care unit with one parent there and the other parent not there. It's just been very difficult. And so the child's home, when the application has been made, may well have been in hospital. In one case that I was in, the child's home, when the application was made, the child was actually in foster care because the child had been removed from the parents for various reasons and then later rehabilitated to the parents. So the court can take a very purposive approach to what the word home means, again, using Article 8 type-based principles about why you should give a broad interpretation of what the meaning of home is. And the second part to that, not quite, specifically jurisdictional requirement, is that one of the applicants, or in the case of a single applicant, that applicant must be domiciled in the United Kingdom. And obviously domicile is a very specific legal term, and it's a finding the court has to make. So either domicile of choice or domicile of origin. And in certain cases that you do, you have to kind of evidence how they have relinquished their domicile of origin in X country and acquired it in this jurisdiction, or similarly where you've got maybe transient individuals who leave international lifestyles, and they're saying their domicile of origin is still in this jurisdiction. You have to be able to evidence how they've still managed to maintain it and that they haven't lost their links here. But I mean, the thing is with domicile, it's always about looking at the individual's future, permanent and future intentions, like where do they see themselves spending their dying days, and you ideally want the answer to be here to show that intention. And the next element is that they have to be over 18, the next criteria, so that's pretty straightforward. And the next bit is section 54.6, which is quite significant, and it's really what I would characterize as being the bedrock of the statute, and that's that the surrogate has to consent freely and unconditionally, understanding what is involved, so that she basically has to sign a form confirming she consents to a parental order, and that she knows that the consequence of this order being made is that her status to the parental status of the child is removed, extinguished permanently, and transferred to the intended parents. And that consent can only be obtained after 6 weeks. It's not valid before 6 weeks. And the court does not have the power to dispense with consent, save for in exceptional circumstances. And the first one is that the surrogate cannot be found or lacks capacity. And in those cases, it's really difficult to, you have to demonstrate that if you can't find them, that you've been searching for them quite significantly, or there are specific reasons why you can't find them. And that also applies, for example, to a spouse. So there have been cases recently where you've had a surrogate who's been married at the time of the surrogacy arrangement beginning and the embryo transfer taking place. And that surrogate and the husband have later separated, but not divorced. And so you need to get his consent too. But if you can't find him, then you're also required to dispense with his consent as well, if you can't find him, and it can be shown you can't find him. And that is a finding the court would have to make, that, it is satisfied that the applicants have done everything they can, and he cannot be found. And then the next and final bit is section 54.8, which relates to expenses reasonably incurred. So in this jurisdiction, commercial surrogacy is not lawful. It's been prohibited since 1985 under the Surrogacy Arrangements Act, and it's a criminal offence to enter into a commercial surrogacy arrangement in this jurisdiction. And it's also a criminal offence to broker or to negotiate a surrogacy arrangement. And I suppose the one thing I perhaps should have started off with is to say that a surrogacy agreement is not enforceable in this jurisdiction. It doesn't work like contract law, and you can't, deploy all of those contractual remedies like specific performance if a contract doesn't follow through. If there's a breakdown in the relationship between a surrogate and a intended parent, it all comes down to welfare. But in terms of reasonable expenses, what it means is that you have to, if it's a domestic surrogacy, so it's done in this jurisdiction, only reasonable expenses can be accounted for, and there can be nothing commercial, otherwise it's illegal and it's a criminal offence. But the law recognises that there are other jurisdictions where commercial surrogacy is a profit-making enterprise, and so the court has the power to retrospectively authorise those payments. So what commonly happens is that if, for example, and the classic example is the California example, you have intended parents who've gone to California, they spent X amount on agency fees and Y amount as what's often characterised as the compensation to the surrogate, which is the payment. The amount that has to be authorised is the agency fees and the amount that was given to the surrogate, and everything else is probably reasonable expenses, such as medication and maternity things, all those things associated that are reasonably incurred. So what you tend to have to do, is the only time that I can venture into anything that remotely looks like a schedule of assets, and my days are over doing schedule of assets a very long time ago, is that you have a global sum, and then you set out what were the kind of commercial costs, and then what were the what was reasonably incurred. And so when you get the global cost, you just say basically it's the amount to be authorized is the global cost less the reasonable expenses, and that, whatever sum you were left with, that's the commercial bit, which is you're saying please authorize that amount. So that's a run through of the criteria. Hopefully that makes sense. Vanessa, you asked earlier about what happens if you don't meet the criteria, or you've got situations of double donor gametes. In those circumstances, you would have to either adopt a child, which can be a bit complicated because you can have if it's a situation where they don't meet the criteria, but one of them is biologically related to the child, that can often be difficult because, of course, with adoption, it doesn't really meet the child's life story where you've got one parent who's genetically related to the child and you're applying to adopt the child, but it is a possible remedy that you could adopt the child. If they're both not genetically related to the child, so it's a double donor situation, one thing that can happen is either to apply for a kind of what I often call a child arrangements order plus, where you basically get an order that says the child lives with the intended parent or the intended parent, and then also kind of a prohibited steps order, quite a comprehensive prohibited steps order that kind of restricts the surrogate's ability to exercise PR without their consent. Sorry, a PSO that restricts the surrogate's PR, and then perhaps a specific issue order that allows them to exercise PR without having to consult the surrogate, because she will still retain PR unless and until an adoption order is made or a parental order is made. Now, often in those scenarios, you'll have a surrogate who's very willing to do that, because I've had cases like that where that has happened, and it's just been well, that's I've done everything in this country, in the US, for example. I've no intention of exercising PR in England, but it does but the child arrangements order isn't the perfect fit longer term, because it doesn't bring with it all of the things that legal parentage brings with it, such as succession or estate planning, because you're not legally a child of that couple. But you can have a curious situation where, for example, to complicate things, make it more confusing, if it was a single surrogate and one of the applicants was genetically related to the child, but they didn't meet the criteria for parental order, then they would be a legal parent if the surrogate wasn't married. So all those kind of things, there are so many different variables. So yeah, as I say, child arrangements order plus is one route. Another route that has been used commonly, maybe perhaps not commonly, quite infrequently actually, I would say, is in some jurisdictions at birth, they can issue an adoption order that says the intended parents have adopted the child in that jurisdiction, even though the child was born through surrogacy. It often happens in America, in some states in America. And that adoption order could potentially be recognised here if they were, depending which country it is, and if that country is on a particular list of countries under a 2013 order. I think it's a statutory instrument where the Home Secretary sets out a list of countries where an adoption order in that country is recognised here, if at the time the adoption order was made in that country, the parents or prospective adopters were habitually resident in this jurisdiction. And if that criteria is met, then it's more of an administrative procedure where the intended parents effectively just send off the adoption order to the General Registry Office, and probably evidence of them being habitually resident in this jurisdiction when the adoption order was made in that jurisdiction, then they can be issued with an adoption certificate from this jurisdiction. So hopefully that makes sense.
It does, but it sounds incredibly complicated if you're the intended parents.
Yes, I mean, I think the key with all of these cases or these scenarios is, which often doesn't happen, and it's great when it does, but is to kind of seek advice beforehand. Now, obviously, as lawyers, not obviously because it might not be well known, but under the Surrogacy Arrangements Act, we can't advise people to enter into surrogacy arrangements because that's also a criminal offence. But certainly you can outline the legal implications of what steps they might take and how they remedy it once they come back to this jurisdiction.